Good morning.
Okay. Thanks, Simon. Morning, everybody. The goal today is to keep this very informal, so obviously if you've got questions, we're happy to field them as we go. But as Simon said, what we thought would be helpful today is to sort of, what Lauren and I did is we sort of aggregated all of our files we've had in the last 5 years and teased out of it the top 10 sort of hallmarks or sort of warning signs that are a tip-off in terms of potential litigation risk, et cetera. And in light of what Simon just said about the expense and distraction of litigation, the first bullet is obviously going to be a little disheartening, which is that you can't actually avoid litigation, but you can anticipate it. What I mean by that is you can't stop someone from suing you. Oftentimes we get clients call us and they're enraged that somebody took the step of filing a claim and they want to just get rid of it. And that's the knee-jerk reaction, and we understand that. The problem is there's nothing you can do in structuring your affairs to preclude someone else from bringing an action. You'll never be able to stop them. The good news is that litigation is sort of, as I say, the hallmark of success. So there is a silver lining here in that typically you get sued once you get to a point where your company has value and people want a piece of the action. And so there is a good news story here. The bad news story, of course, is, as Simon said, it's a distraction and it's an expense. And so the best thing you can do is try to structure your affairs in a way that minimizes the risk of litigation and makes it sort of unpalatable for whoever the litigant may be to come after you because of the way you structure your affairs and because of the cost of doing so. Oh, there we go.
All right, so in terms of structuring your affairs to avoid litigation, that is where we get to our second point, which is being proactive in dealing with disputes as they arise. And so this is really stemming from Craig's point in terms of preventing litigation to the extent possible. And I find a lot of early stage companies are actually very good at if there's a situation coming to perhaps someone at Osler that you work with, and then they'll often, if there's a litigation type scenario, they'll pass you on to Craig or me, and oftentimes they'll be surprised when the advice is, we got to settle this and make this go away as soon as possible. They're expecting once they get, put over to the litigator that we're going to be all aggressive and want to start litigation or be aggressive with the other side, and that's often not the right answer. Usually our advice will be, what can we do to make this go away as quickly as possible? And so giving sort of the opportunity to do that is, of course, being proactive. And if there's a situation, let's say, for example, with an employee that's departed, with a contractual counterparty that looks like they're going to default, with an investor that's sort of making rumblings that sounds, like there could be disputes down the line, then that's come to seek advice sooner rather than later in terms of dealing with it. Any of you that have been involved in a litigation scenario know that the longer things carry on, the more difficult it is to resolve. People become entrenched both from an emotional perspective, from a financial perspective, and then, you're down the road of potentially in litigation, or you're in a situation where someone is going to want a lot of money from you before something is going to go away. Also, just because of the nature of, and I'm sure a lot of you are in this position, a lot of times these companies are founded on friendships, relationships, people going into business together, and we all know that having a relationship deteriorate can then also be an massive sticking point in terms of resolving things. So to the extent that you can deal with something sooner rather than later, it's always going to make it easier for you to deal with in the long run.
So the third sort of tip is, once a dispute goes to litigation and something gets filed on the public docket, it's essentially impossible to get it off the docket. And that's important for a couple of reasons. First of all, if you're contemplating litigation yourself, because oftentimes we come at this from the perspective of responding to claims, obviously there's an equal or greater likelihood that you will have claims you want to advance yourself. The difficulty is, if you go down that road, or if somebody else goes down that road, once a claim gets filed, it will be on the docket in perpetuity. Now, that may not be problematic, but the reality is, for example, if you are looking for capital investment, if you're looking for investors, or if you're entering into a partnership or strategic alliance, oftentimes they will search the docket. And the mere fact of litigation has been known to scare away investors, regardless of the merits of the litigation. So you may well have, for example, if you're sued, you may well have a very solid defense. It may be an entirely frivolous claim, but oftentimes investors just don't want to get tied up in anything that has litigation, because not so much for the concern about the risk of the claim itself, but rather what it's endemic of or what it represents. So the very fact of having something on the public docket is obviously potentially damaging, at least. And the other thing is, to get rid of the claim itself is also expensive, in the sense that even if, as I say, it's an entirely frivolous claim, it has no merit to it, to actually go through the process of proving that to a court. So, for example, we have mechanisms such as summary judgment or motions to strike. And yes, those are ways of forcing someone to get rid of their claim. But that in and of itself takes time and takes money. You have to file materials. And frankly, it's a headache that you, if you can avoid it, you should. And this is not to say that you should be scared of litigation. If someone compromises your rights, you absolutely should pursue them, and you have every right to do so. But before elevating to this sort of public docket, you just want to think long and hard about the consequences of that from a public perspective. And the sad reality is, just as an adjunct to that, is oftentimes people will file a claim as a means of leverage. And they'll put things in a claim that frankly are baseless, and they're designed to effectively put you in a difficult bargaining position. That will stay on the public docket. You can't sue someone for defamation, for example, on the basis of what they put in a pleading. So it does give them a protected sphere to sort of make your life very difficult. So again, really this goes back up to point number 2, which is, to the extent that you can structure your affairs in a way and also deal with problems as they arise before they go public, all the better.
And just to add to that, in terms of when you're wanting to commence litigation, oftentimes I'll meet with clients and they really, whether on principle or because they feel like this is what they should be doing to be aggressive, they really want to bring a claim. There are a lot of things you can do before you get to that point, and that's how sort of we and your colleagues that you've worked with can help you. And some of the tools that we'll talk about too can sort of provide you with leverage, for example, in certain employment agreements, that can help you actually create leverage without having to file a statement of claim. We've even found, for example, sending a letter with a draft statement of claim can get people to do things that they might not have otherwise have done. So just sort of bear in mind that litigation is not your only answer, and there's a lot of things that we can help you do to create leverage in a particular situation. And so I guess that sort of leads into our next point, which is cutting corners at the front end poses litigation risk at the back end. And this is where a lot of your corporate and commercial colleagues and friends at Osler come into play, in that they can help you structure various business arrangements, various employment arrangements to ensure that you're protected. You can sort of go on and Google like COP, for example, and you can find a draft online, and that might seem like a good thing to staple at the back of an employment agreement if you hire someone. But the reality is it's important to have the necessary protections in place in any contractual arrangement that you enter into. And so that is where you really need to think about, okay, what, from a negotiation perspective, what do I need to protect myself against from a litigation perspective? And how can I best achieve that based on my negotiating position? And so, again, this is important because sometimes things that you might not yourself contemplate as a startup, for example, the examples that we've encountered are certain rights and sort of situations vis-a-vis investors, and how you're going to structure your agreements with them, and how, thinking about 5 years down the road when you're a company that's doing extremely well and investors are going to want to sort of have more of a piece of it than they do, or they're going to want certain rights, they're going to want to see certain documents. You got to think about that all up front. Same thing with employees, as I'm sure you're familiar with in a lot of your spaces. employees tend to move around quite a bit, and they often will want to try to go to competitors. So you need to make sure that you're properly protected in terms of employment agreements that contain the necessary clauses, which we'll talk about. And also in something I've been working with Steve Dickey on just recently, when employees leave, having appropriate separation agreements in place that can then continue to protect you. Also, in terms of dealing with contractual counterparties, be wary of, for example, suppliers that might require you to agree to certain standard terms. They might just look like standard terms, but make sure you consider them, or have your counsel consider them, so that you can make sure that you're not going to sort of be left in a position that you don't want to be in. For example, if a supplier can't provide something, that type of thing. So there's a lot of examples that we encounter, and it's always the situation, and you can't think of everything, but you always sort of wish you had thought of something and structured something differently at the front end, and sort of giving appropriate thought to that can help you do that.
Yeah, that's a good point. Just to add to that, I mean, we've had several examples. It's very tempting to think that a particular transaction is identical to another transaction that you've done recently or done in a different context, and you just take the agreement that exists and you say, and I know this sounds self-serving because effectively I'm suggesting that you call Chad's group and seek their advice, but I do mean it, because a lot of the times the fights we get into are because someone has taken an agreement from context A, tried to recycle it for context B to sort of save money on drafting and preparing a new agreement. And then, frankly, the situation doesn't apply, and the rights aren't there, and the protections aren't there. So, although it does seem like another needless expense to bring in someone else to draft an agreement that's seemingly similar to something you've done previously, at least have someone give it the once over to make sure that it applies, because you'd be surprised at how the slightest change to a particular context can invalidate an entire agreement. And in a similar vein, I mean, we're well aware that oftentimes sweat equity, grants of equity, things like that are the easiest way. And frankly, there's nothing wrong with it. It is an appropriate way by which to leverage resources from partners or from service providers. I would say 80 to 90% of the disputes that I see, at least coming out of this market space, relate to fights over equity grants or share grants, and what exactly was granted by whom, to whom, when, on what terms. And you'd be amazed at the breadth of what goes on in terms of how these are granted, because it's often done ad hoc, it's done very informally, it's done very quickly. Things are moving the pace is not what people are used to, and you just need someone in to come in and provide service in whatever it is. So you grant them options, you grant them a stake in the company. It's only after the dust settles that then becomes a major dispute. And it is truly, as I say, it's upwards of 70 to 80% of the disputes we see on the basis of basically fights over what equity was granted or what rights were granted to whom and when. So the message here is make sure you document everything you can. And again, I know that sounds self-serving, because to do so, you probably have to avail yourself of legal services, but it is important, because even if it's done between friends, as Lauren rightly said, personal relationships often change. It's the difficulty of mixing business with pleasure, obviously. So try to make sure that whenever you can, if there's going to be any grant of equity or any rights granted in respect of your company, it's well documented, you're fully protected, everybody's on the same page as to what's being granted to whom and when, because that's going to be the substance of litigation going forward.
Yeah, absolutely. And you wouldn't believe how, or maybe you would, how even sort of by virtue of a promise of equity that's never documented, how difficult that can make things at the back end. So for example, you could have an employee that's left, and you might be willing to pay them more than the equity in the company is actually worth at that point. Maybe you're willing to pay that to make that dispute go away, but you're not willing to give them an equity stake in the company just by virtue of the way your company's structured. It makes it unbelievably difficult to resolve something when someone feels they have an entitlement to a company that they see is doing very well and growing. Because they'll think, this equity, this could be worth, this is the next big Facebook and I should have had an entitlement to it. So just sort of even any discussion about the promise of equity, just even be wary of that in the way that someone could ultimately try to claim an interest down the road.
The orders off that. I'll quickly do this one then.
No, go ahead. Go for it.
The IP one. So Lauren already alluded to this, but non-competition, non-solicitation clauses. Obviously, you want to be mindful of these from two perspectives. One, to the extent that you are bringing in a new partner or you're bringing in employees, you want to make sure you know what sort of restrictions they have in place, in the sense that if they are limited in their ability to either involve themselves in the company or limited in their ability to do certain things, you want to know that up front, because obviously that's going to be very difficult to litigate after the fact. And if you are the company, they're coming after you, even though the employee or the individual is the person who will have entered into the clause and the provision, there's no question you will be brought into this fight as well. You can't just stand on the sidelines and say, I didn't know about it, you guys deal with it. They'll always go after the deep pockets. Conversely, you want to make sure that you tie up your employees and your partners in a way that protects your rights going forward, because as we all know, movement in these spaces is quite common, and you want to make sure that someone doesn't jump ship and take away your client roster, your IP, et cetera. On that note, and I see Steve here, get some employment advice on this as well, because the reality is, as great as these clauses are, and as important as they are, and they absolutely are, they're not silver bullets. They're difficult to enforce. They have limitations. So you shouldn't go into this thinking as long as you've got a clause in there in your contract, you're golden, because the reality is you may be, but there are limitations, and so you just want to make sure you know where the sensitivities are so that you draft it properly, and also so you structure things appropriately.
So similarly, confidentiality clauses, again, very important from the perspective of employees that are moving around, because these ones I think are actually arguably sometimes important and potentially sort of more of a leg to stand on from a litigation perspective. Sometimes the non-solicitations and non-competes can be struck down on the basis that they're overly broad or burdensome and whatnot. But confidentiality is of course very important, but you have to make sure that you have the right confidentiality agreement. I'm always very happy when a litigation matter is brought to me and I see that it's our standard COP terms, because I quite like them. And I think there are good things in them that can help enforce confidentiality obligations without having to do something like seek an injunction, which is very difficult, very costly, very risky, and not necessarily going to get the right result. At the end of the day, the priority is just keeping the confidential information out of the hands of competitors when it shouldn't be there. So for example, the draft that we use has things that can be done in the interim, such as share the COP, and that's confidential information, and proprietary property agreement with a competitor to say, hey, by the way, this person that is now trying to disclose confidential information to you, they're bound by this agreement. And so to the extent that you are going to avail yourself of any confidential information, this is notice and you'll be on the hook. It can also serve as leverage to say to employees, well, we have the right to disclose this, and we will certainly do that to the extent required. And no one really wants their reputation and, well, presumably anyway, they don't want to have their reputation tarnished with other prospective employers. And so making sure that that's appropriately protected is very, very important. And I'd say potentially second to disputes about equity interests, I'd say is disputes about confidentiality in one form or another. And again, the converse also applies in that if someone is coming to you trying to shop an idea, or they're saying, hey, I'd like to work here and let me do a pitch to you and I'll just use this document that I happen to have. Be very careful that it's not actually potentially confidential information from one of your competitors, because then, as Craig says, they are going to come after you. They may come after the employee as well, but that'll be ancillary to their goal, which is to stop you as the competitor from availing yourself of the confidential information that they say is protected in terms of the former employee's confidentiality obligations. Me again. So IP, intellectual property protections are essential. This one I think is pretty straightforward. And again, just an invitation to feel free to contact us in terms of the IP experience that our colleagues have, because this is the foundation of this space and the companies that you guys are involved in. Protect the assets, figure out what you need to do that, figure out whether it's something where it's possible to appropriately protect it, and just seek advice on this front, because in this situation it's obviously very powerful currency, and it makes it much easier to protect at the end of the day.
Yeah, just plug on that. I will freely confess that most of the IP laws are beyond me, but I'm always amazed when we bring in our IP colleagues and we want to do X, and they tell us you can't do X because the law doesn't allow that, particularly around assignment of IP. So you just want to be careful that you get the advice up front so you know exactly what you can do. It's not just a case of protecting your IP, which of course is obviously important, but it's also, if you're structuring a transaction, you want to know what limitations there are in place about assignment of IP, and also just make sure you paper it correctly. Just very quickly on jurisdictional risks, a lot of the times we're dealing with companies who have investors or partners or potential acquirers from foreign jurisdictions. To the extent that you're dealing with other common law jurisdictions, particularly US and Canada, it's not really an issue. I mean, to be honest, it's not too significant, although you do want to think about if there is a dispute. If a dispute is likely, do you want to have that dispute aired in, for example, the courts of Ontario, or do you want to have to travel to California or New York to fight on their home turf? That in and of itself is important. But more generally, we've had a couple of instances recently where the jurisdiction in which the counterparty is involved is not your typical standard common law jurisdiction. A lot of South American companies are involved in the space, obviously, a lot of Asian markets as well. You want to think about, when you're structuring your agreements, are there laws in these foreign jurisdictions that are going to compromise you or expose you? And if you can protect yourself up front, do so. I mean, the easiest thing that we do is we include choice of law clause, jurisdictional clauses that basically say, to the extent that there is any dispute surrounding these contracts, we'll fight them out in Ontario. Ontario law will govern, or whatever jurisdiction works. And that's an easy fix, but to be honest, it's one of those things where if you don't have that and you are dealing with a jurisdiction where the law is not in your favor, that can come back to bite you, and it's something that's so easy to include and so costly if you don't include it properly.
And that goes back to the drafting point as well, in terms of making sure that things are drafted properly at the outset. Sometimes a jurisdiction clause is, for those of you that have negotiated agreements, it probably wasn't your biggest sticking point. It might have just been something that someone threw in because it was in a precedent. And so it may be just a matter of making sure and taking notice. And if you're, providing for a jurisdiction that there's no way you'd want to be there, just, propose Ontario, but I think it's a matter of paying attention to it more than anything. So our last point is the importance of good governance. So this ties into disputes that we see, and it's often sort of, as Craig was saying, when companies are into litigation, it's because there's something to fight about. And one thing to fight about is investors that are saying, this company is not being run properly or in the way that it should. So there's a couple of statutory remedies in Ontario called the oppression remedy and a derivative action, which are relatively broad remedies that basically give concerned stakeholders, which are often shareholders, but they can be sort of other stakeholders in the company, to say that this company is not being run, it's being run unfairly, in an unfairly prejudicial way to my interests. And often, and this can sort of be a very broad complaint, that it's often, the company is being managed by people at the top. They're not appropriately abiding by the documents of the company, say the unanimous shareholder agreement. They're not calling meetings in the manner that they're supposed to. They're granting themselves compensation without appropriate approval. And so they're saying that the conduct is oppressive, or a derivative action, which is similar, which is basically a company can sue on behalf of the company for relief that should be made to the company. So I'd say in this space, oppression actions are maybe a bit more common, but they afford broad relief. And they often stem from a perception, whether it's real or imagined, or whether there's from some sort of group that's running the company in a manner that does not accord with good governance practices. And so what does this mean? It means being very familiar with, for example, what a unanimous shareholders agreement requires in terms of meetings, in terms of ability to sort of have people on the board that's governing the company, making sure that, and this is also sort of sometimes quick advice on this can really help you get out of a difficult situation. I dealt with a situation recently where there was a dispute about ability to rule on compensation, and the CBCA actually provides that directors can do that, but you sort of have to know what you can and can't do and how it needs to be reasonable and make sure that it accords with the way that things have been done in the past. And just, it's sort of a broad bucket, but making sure that you're aware of requirements and are checking on requirements as and when required. It can really help avoid a piece of litigation, which can actually be sort of quite significant if an investor is saying that my rights are not being properly recognized. You often, and many of you may be in a situation where an investor has a particular seat or a particular voice based on the unanimous shareholders agreement. So to the extent that those rights need to be protected and they can't sort of be readily amended. So again, careful at the front end, but also make sure that you're aware of what's required, because that can sort of create a whole host of issues.
Yeah, I think this and the grants of equity are probably the two most common things we see, in the sense that people are often unhappy with, if the company's going in a direction that they don't agree with, the first thing they do is they allege that they've been oppressed. Mm-hmm. And again, as Lauren says, it can be stakeholders. So it doesn't even have to be a shareholder. It could be a creditor. It could be anybody who has an interest in the company technically can bring an oppression action. And basically, the gist of it is they go to the court and say the company is not being run in a fair and equitable manner, and you, court, should intervene. And there's a statutory list of remedies that the court can grant, and it's extremely broad. The court can do any number of things. So this isn't a case of just granting someone damages. This is a case of they could issue shares, cancel shares, they can freeze assets, they can force a sale of assets, they can do any number of things. And there's even a basket clause that they can do anything else that's equitable and appropriate in the circumstances. So it's a very powerful tool, and it's a heavily used tool in this space, because anybody who's displeased with the particular direction of the company can avail themselves technically of this. And this is most commonly how it plays out, in the sense that they run to court and say the current leadership of the company is doing it improperly. And so the best defense against all of that, of course, is just having institutionalized processes in place for good governance, making sure you have your board properly appointed, making sure you have the committees, making sure they're reporting properly. And that's the sort of stuff that evolves organically. But, you know, the early stage companies oftentimes don't have all these structures in place at the outset. Obviously, this group here, the EHG group here, is here to help you to get those in place. And those are your best protection against a future claim. Again, you can't stop someone from bringing an oppression claim. They probably will do so regardless of what you do. But a court will be very impressed if you come to them and say, well, look, they're just disgruntled, they're unhappy with the direction it's going in, but look at the structures we've got in place, look at the reporting lines we have in place. You know, our annual filings are all up to date, disclosures are up to date. In that context, the court is unlikely to wade into that and say, well, we disagree with the way you've been running the company, because obviously there's the business judgment rule, et cetera. But if you don't have those things in place, it does give them a leg up to say that, you know, you're not running the company the way it should be run under Canadian corporate law, and therefore the court should intervene. So all of that is, again, a pitch to make sure that as you're going forward, the formal structures that you have in place are almost as important as anything else, because they're the sort of outward-facing systemic mechanisms you have in place to show the world that you are doing things appropriately. And if there is a dissatisfied faction of people who don't like the way the company is going, that's fine. But it's not because the company is being improperly run. It's just because there's a difference of opinion, and that's not a basis for a lawsuit.
Question.
Yes.
Are you aware of templates or checklists or child's guide for some of these areas where, you know, your board of directors said this, notice, you know, standard statutory notice requirements of that sort of thing. Because let's face it, small companies are going to be reluctant to call an expensive lawyer to say, you know, how do I set up my folder, right? Because it just feels so open-ended.
Yeah. No, it's a fair point.
It's useful to have.
Yeah, and we have, I'm probably not the person to answer that because I'm usually the guy who deals with it after the fact, but I guarantee you somebody in this room, and I'm sure we have templates and I'm sure we have resources like that because it comes up all the time. Again, it's not a one-size-fits-all solution, but I take your point, and they're the basic sort of, there's the tick list, right? Like there's the list of issues that you have to do regardless of what space you're in, regardless of the size of the company. You just have to have these basic things. And I know we have resources like that, so I will follow up afterward and we can see what we've got. But it's a fair point because you're right. You're not going to call a lawyer every time you have a debate about, you know, who should, how big should the board be? What committee should we have? But at the same time, it's so important that it is the kind of thing you want to get right out of the gates, because if you screw it up, it can have repercussions.
This type of issue too is another one. They're all in a category that I'd put get out ahead of it. But I think this is one of these things where sometimes you can sort of sense that something is going in the direction of a possible oppression claim based on dissatisfaction being voiced by certain factions, as Craig mentioned. And a lot of these things, it is possible to come to a creative solution and figure out how we can make sort of in a company, make everyone happy. Not always, but I sort of tend to believe that there is a solution to be had in these situations. But again, you have to get out in front of it before people, before it's too far gone, before people are too mad, and sort of figure out, you know, what do they really want? Sometimes they'll sort of allege oppression because they want something else. They sort of, I've had a situation where they wanted to sort of cash out their equity and there wasn't a great mechanism for it. So they made oppression rumblings, and then we were able to get a deal at the end of the day. So again, really important to sort of be in front of these things as soon as possible to have the best sense of really thinking strategically about it, and avoiding that oppression claim, because that's where you don't want to be.
Yeah, totally. Yeah, and so the two, if you want to distill this list of 10 down to two things, I think Lauren's absolutely right. Be proactive, and number two is properly document everything. And you won't know how to do that until you get to this particular circumstance you're in, but just make sure everything is papered properly, because that's going to come back, and it's going to pay dividends if and when you are ever faced with litigation. If you can point to properly structured agreements that have all the provisions and protections you need, it's going to hem in anybody who wants to try to make your life difficult down the road. Same for governance. As long as everything is structured in place, a court is unlikely to intervene and second guess the business judgment of the company. So document and be proactive. Any questions, comments? Yes, sir.
Just with respect to the oppression, typically a result of like a breach of the USA or corporate legislation. If you follow your USA, you follow the bylaws, CBCA, you really be affected?
Yeah, so oppression is that nebulous claim that basically is, okay, even if you did everything right, the way you've done it, it plays out unfairly. So you can still be onside everything. And you can still be claimed to have acted oppressively because, you know, the net effect of it actually prejudiced either a sub-interest or a group of stakeholders. But the reality is the best evidence of improper conduct is improper behavior in the sense of it's non-compliant with the USA, it's non-compliant with whatever's in place at the time. If you comply with everything else, can you still be found liable? Yes. Is a court likely to do so? Probably not, unless it's egregious. I mean, there are lots of instances where, for personal reasons, groups of shareholders have been targeted, and it's been done in a way that's technically onside, and that's where the oppression remedy is supposed to come in, which is you don't have to have acted in violation of the constating documents to still have acted oppressively, but the reality is that's a tough thing to prove if everything was done properly, procedurally. Anything else?
In terms of litigation, I'm just wondering if you can comment on when, so in progress to say, a new agreement or relationship, when it might be able to introduce arbitration
You got the expert right here.
So the question was when it might be appropriate to use arbitration in the context of, and is this specifically in an employment context?
No, it's more like dealing with, say, foreign companies on sale or an agreement.
Yeah, so Craig and I tend to fight about who's better at arbitrations. That's why he's saying it's the perfect question. But it's actually a great question. So I think it depends on the circumstance. In the situation, for example, when you're dealing with a foreign company, sometimes arbitration will make more sense because then you don't have to say, I'm going to go to the court of Spain or California or Guatemala. You can say we are going to agree on a process whereby we're going to pick a decision maker or decision makers, and they are going to resolve things for us. So in a multi-jurisdictional context, I think it makes a lot of sense. Arbitration clauses, they're sort of another, I put them in the category of jurisdiction clauses. And it's something I actually feel quite strongly about, is they have to be structured properly for the nature of the dispute that might arise. Just having an arbitration clause in and of itself may or may not be good at the end of the day, because you could end up in a situation where, say, you have a sort of a small dispute, but yet you're having to deal with it in front of an arbitral institution with 3 arbitrators that are going to charge you $1,000 per person, and the arbitral institution fees will be quite expensive. So in the context of a smaller dispute, I actually think then having an arbitration clause can sort of be less economical. But if you can give some thought at the front end to what type of dispute might arise in the particular situation and how it would be best to deal with it, and this is something we can help you with too, I think arbitration clauses can resolve things quite efficiently. Another huge advantage is you can provide for confidentiality. So this deals with a lot of the issues we've been talking about in terms of people saying, well, I'm going to force you to go to court, and then your dirty laundry's out in public. You can specifically provide in your clause that there'll be a confidential arbitration process, and that can actually be quite advantageous. So I would say absolutely arbitration clauses can be good in the circumstance you're describing. Just make sure that they are appropriately tailored to your dispute. I'd say sort of be careful about picking an expensive institution, that type of thing. And be careful about a very overly cumbersome process that's set out at the outset, because sometimes that's not going to necessarily apply to what you're dealing with either. So hopefully that helps.
Anything else?
With respect to jurisdictions, typically you see people, like especially with NDAs, changing the governing law to their own jurisdiction. Do you recommend choosing like a middle ground in those cases, like a jurisdiction in between your place?
Yeah, no. So the question was, when you're fighting over jurisdiction, you can't agree. Do you pick a middle ground, sort of neutral territory, I guess? I would recommend against that. I mean, it's an option for sure, but to be honest, you want, let's put it this way, your ideal is to have it in your own home court, right? So your first stop should be make it wherever you are. So if you're in Ontario, make it in Ontario, because that way you know the laws, your lawyers know the laws. You don't have to travel to fight, as mundane as it may seem, dragging witnesses to a foreign jurisdiction and fighting in a foreign proceeding is extremely expensive relative to doing so in your own backyard. If you can't agree on that, the difficulty of picking a neutral territory is that a court may well not even accept it, because if it has no attachment to the jurisdiction, you may choose a law that applies, but the forum, so where the fight happens, wouldn't be where that is. So the net effect of that would be you'd have, for example, a fight between an Ontario company and a California company, and let's say you pick Alberta law. I'm just choosing that, right? Or New York law. The problem there is you would never have the fight in New York because there's no ties to that jurisdiction. So you'd either end up fighting it in California or in Ontario, but you'd have to apply New York law. And what that means is both sides have to bring experts to give expert evidence on what the law of New York is. So it just increases your costs. So to be honest, you'd almost rather be in, if you're the Ontario company, if you lose the fight and can't get it in Ontario, you're almost better in California, because Otherwise, you're both sort of fighting a foreign law in whatever jurisdiction you end up in. But the other thing is on jurisdiction, it's a nice give and take, right? In the sense that if you're fighting over a bunch of issues in a contract, jurisdiction is an easy give if you get something else, so it might be a trading point. So push back. Oftentimes what we'll do is we'll push back and we'll insist on Ontario law if we know it's a sensitivity to them, and then we'll give on that if it gets us something else in the agreement. So it's, as I say, it's an easy give because at the end of the day, you're hoping it's never going to come to pass anyway, because you shouldn't be entering an agreement where you know you're going to have litigation down the road. But ideally, again, if you're dealing with common law jurisdictions, the differences probably aren't going to be too great. If you're dealing with foreign jurisdictions where the laws are fundamentally different, then you want to be very careful.
Just a couple of points on that is to note that one way to get away from a jurisdiction fight is to provide for arbitration, because jurisdiction becomes less sort of, the seat that's chosen is typically the seat that's chosen. It doesn't have to have any connection whatsoever. So then you can provide a neutral place like New York. Two is, interestingly, I definitely 100%, if I was putting, advising on a jurisdiction clause, I'd say to go for Ontario, assuming you're an Ontario company. Although I did recently see a situation where a company chose to avail themselves of a jurisdiction clause that was provided for Georgia because the person that they were interested in, who they were worried about sort of breaching their confidences and whatnot, was from Atlanta, and they felt it was more sort of public exposure to him to fight in Atlanta. So then in that case, we just referred it to a law firm in Atlanta. So anyway, I all to say, sort of, it all depends on the situation, but it's not a total loss, as Craig says, for it to be in the other jurisdiction.
Yeah.
Are there jurisdictions in particular, well, I was going to say not necessarily, that you would try harder to avoid? And I guess, in my experience, I would say, obviously, it's very challenging if the jurisdiction is Quebec, because that introduces a second language requirement. But also in other contexts, like I've heard people say, like, don't go to California, you really don't want to be in California for such and such a type of issue. Are there any sort of red flag jurisdictions where you would go and try not to?
So sort of the question is, are there red flag jurisdictions that are sort of non-starters out of the gates? Again, I don't want to start casting aspersions on foreign legal systems. I think the reality is if you're dealing with anywhere in the U.S. or Canada, no. I mean, there are complexities that get introduced, and oftentimes the point was made, well, people say to stay away from California. There are certain, the interesting thing about California is it's got a very left-leaning bench, and you know where they stand on certain issues. So I suspect oftentimes that comment is made where if you're in a particular position, you know which way the court's going to go because they've done it 100 times beforehand. But it's not so much that the law of California is anyway materially different probably than the law of Ontario on this issue. It's more the way the courts apply it. It's a difficult one to sort of assess in the abstract because you don't know what side of an issue you're going to be on in the abstract. But no, I think really where you want to be careful. We've had a dispute recently where it was a South American company, and it's likely going to be governed by the South American law, and the law is just fundamentally different than what we're used to and what we know. And the difficulty is twofold. One, the rights that we always assumed would play out are not as clear cut because the courts down there take a different approach. And two, we can't advise. So, to the extent that you're comfortable with your advisors here in Canada, they're going to be hamstrung if they're, advising in respect of a foreign transaction because they just can't do it properly. So you'll have to get local counsel. You have to get comfortable with them. So sort of the further afield you go, the more difficult it is, I think.
Let's leave it at that. Thank you. So just quick housekeeping item.